Thomas, just tell us basically what happened in there today.
Well, it was just a preliminary hearing, which, as you know, has a very low burden of proof. We have to establish probable cause that each crime was committed and that LeForce committed those crimes, which we did with the least amount of evidence we could put on at this time, and we easily did it. This is a pretty straightforward case.
Tell us about the fourth aggravator that you had on the bill of particulars.
We filed an amended bill of particulars today alleging a fourth aggravator, and the fourth aggravator is that he created a risk of death to more than one person at the homicide scene, that person being the witness, Judy Mantle, who was scared she was going to be shot and could have easily been harmed either by his car or the gun or whatever he wanted to do. So we have four now. You know, the first one's heinous, atrocious, and cruel, which means he physically suffered before his death. One is the continuing threat aggravator, which is based on the nature of the crime itself, that he's a continuing threat to society, and based on his progression of antisocial behavior and criminal behavior through the years. The third one is that Deputy Wade was killed while in the line of work as a police officer, and then the fourth aggravator.
You said you did this with the least amount of evidence. There's a lot more that we're going to see at trial on this thing.
Well, certainly, yes. But preliminary is only a very low threshold for the judge to make a determination, can this case move forward? Beyond a reasonable doubt isn't an issue until trial. So you just put on what you need to establish that. We've already provided the defense with our files, so they're already aware of all the evidence we have. It's not like they needed to discover anything at this hearing. And that's pretty typical of how we do preliminary hearings.
It sounded like the defense was trying to discredit one of your witnesses there.
Well, we would have expected them to do that. Obviously, there was drug use involved, and we thought they would go there. However, I thought all four witnesses did very well and told the jury what they experienced and what they saw and how it impacted them.
Is there a possibility that this is going to move to a different county just because of the nature of the crime?
We won't know until after formal arraignment when Judge Corley sets motion hearings. And in any capital case like this, there's going to be dozens of standard motions filed. I would not be surprised to see that motion. There's a lot the defense would have to prove to be successful in that kind of motion. I anticipate this trial will be held right here where the crime occurred.
What does it mean that they demurred accounts?
When the defense demurs, they're saying that the evidence isn't sufficient for the judge to make a bind over. That's the legal terminology for we demur to the evidence. It's just not there.
How is the family after today?
The family's still very much grieving. I mean, they have lots of emotions. I see grief, I see anger, I see exhaustion. It's just very hard for them. I'm sure they wish it wasn't going to be till November when we had a formal arraignment. We have talked to them and prepared them a lot for that. When you're dealing with capital cases, if you get the capital OIDS crew, I mean, that is what they do. That's the only thing they do. And so they're doing it all across the state. And we have a lot of murder cases all across the state. So when we get to formal arraignment, it's going to be looking at the judge's calendar, looking at their calendar, and looking at our calendar. So that's one reason I wanted to get it before Judge Corley as soon as possible, so we can reserve a day before they have anyone else's set.
So the arraignment's in November, and then they'll set the trial date at that time.
I don't know if Judge Corley, well, we'll ask him to set the trial date. He'll set a series of dates. He'll set, hopefully, the trial date. He'll set final pretrial dates. He'll set pretrial dates.
Is it standard to seek the death penalty for these types of crimes?
It is never standard to seek the death penalty. The death penalty only applies to an extremely small section of first-degree homicides. You can have a first-degree homicide that does not qualify for the death penalty. In order to qualify, you have to know up front, or we have to have felt that we have enough evidence to prove aggravators that are listed in the statute. And we think we have ample evidence of 4 of them. So it's unusual that it's a death penalty case. The minute he killed a police officer, it became a death penalty case, because that is one of the aggravators.
Do you plan to call any further witnesses other than those who testified today?
At trial? Oh, yes.
Do you know about how many witnesses?
No. There will be lots of witnesses, lots of evidence that you don't see in here, but no.